Yes, Mr. Gibbon.
My Lord, I should begin by a clarification. This morning, when I was asked about the meaning of the word person, off the top of my head, I confused myself with private person, which is a similar concept. The definition of person is, in accordance with the Interpretation Act 1978, any person, including a body of persons, corporate or unincorporate. That is a natural person, a legal person, and, for example, a partnership. And that's the phrasing used in that definition. It doesn't affect the ultimate answer I gave to the question, but I should make that clarification straight away.
Thank you.
So whatever the official solicitor is, he's probably a person.
He probably is a person.
Yes. Is he a body corporate? Is this a corporation sub? No, he probably
I
isn't,
don't think he is a corporation, so we'll look at Minotaur. I think that...
It doesn't matter to your argument.
No, it doesn't. And before the short adjournment, I'd given two steps in a pausing there sort of moment for the advocate. The first was the paradigm situation, and I'd then gone on to consider the agency situation. I was going to go on, as part of the forensic process, to talk about then the third layer, those lacking capacity. But I'm looking at my notes again. I suspect in the course of argument this morning you've heard the submissions I'm going to make. I can make them again, but in essence they come to the point you've already heard, my Lord.
Sorry, was that in relation to lack of capacity?
Lack of capacity in the sense of the global catching of people who don't bring the complaints themselves, so authorised by law. So I was going to particularly focus on, obviously, the bankruptcy situation as being a kind of aspect of lack of capacity. But the submission, and your Lordship's heard it, I think, in the course of argument this morning, is that if one continues in the case of agency to look at the underlying eligible complainant, then the position we respectfully say, just as a matter of keeping a coherence to the structure of DISC, ought to be the same in relation to those other parties, including in 2.7.2r.
Is it common ground, as I understood it, you can tell from the wording of 2.72 itself that it applies in the case of death, and it's common ground as recorded in the judgment that it applies in the case of bankruptcy. Is it also common ground that it applies in the case of someone who loses capacity, and then there are various procedures under the Mental Capacity Act or through lasting powers of attorney in which other people can bring claims?
It's not been addressed in any detail in the course of argument at any stage, but I understand it is common ground that they too are similarly caught. I believe in the course of argument that was addressed below very briefly.
Yes.
And certainly I can add this, although there might be a wider debate about the relevance on particular points of the consultation materials, certainly as to the question of mischief, one sees their specific consideration of bankruptcy, mental incapacity, children, as coming within the intended scope in the course of the...
I can't imagine many children have PPI mis-selling claims.
I've not included it at the forefront of my submissions, my Lord, but certainly it does seem to have been specifically in contemplation. And perhaps I'll put it this way. Of course, if one stands back from DISC covers many things other than PPI. But again, that might raise separate complications of various sorts, not least that children don't normally have the capacity, for instance, to bring proceedings. But as I say, that's not been investigated. I don't propose to delve unnecessarily into that. This might be an appropriate point to answer the question that Lord Justice Singh posed just before the short adjournment. There is a partial answer in the skeleton argument for below, but I'll repeat it here. One of the questions asked was, well, what happens where somebody is made bankrupt? And what if the time limit had expired prior to the official receiver being appointed trustee? And what the official receiver's position is that time doesn't start afresh in the official receiver's hands. It's not the case that we could suddenly turn around and say, well, for this purpose, we're the complainant. We don't know. No, the complainant remains the underlying complainant. If that complainant knew within 3 years prior to the bankruptcy,
or ought to have known,
Also fair.
And that's consistent with your fundamental submission, that the knowledge is that of the complainant.
Yes.
Do you also accept that my Lord's question was in relation to a case where the bankrupt knew more than 3 years before the onset of bankruptcy, so his claim was already barred before bankruptcy. There's a variation in which you might know a year before the bankruptcy or a year before death. Do you get another 2 years or do you get another 3 years?
My Lord, again, we addressed this in our skeleton below. The short answer is, we're given the extreme example of somebody who goes bankrupt a day after the end of the 3-year period.
Yes.
And we said again that we accept that the OR, however artificial it might sound, would just have 1 day left.
Yeah, you can't do better and you can't do worse.
Can't do better, can't do worse, my lady.
You step into the shoes of the bankrupt.
Well,
for those purposes.
forgive me for interrupting. You can do better in the following scenario, that if time has not yet begun to run, by the time of bankruptcy, you say in relation to the OR there is no time limit.
In those circumstances, it would remain the case, we respectfully say, that the underlying eligible complainant could still know, because we are in contact. Let's imagine this situation. The official receiver comes along, doesn't know anything more than what the underlying complainant tells him about the mis-selling of a particular product at a particular time. He may not know anything about it. It's dependent on what information the bankrupt's able to give. And one of the bits of evidence is, or has been below, that actually experience tells us that bankrupts simply haven't known they've had PPI.
Well, that's fine, but I think Mr. Herberg's fundamental submission is that once you're in charge, you're the person who's going to have an interest in pursuing the complaint. You're the person who's going to know the relevant facts. You're the person who is deciding when to make the complaint. Am I within 3 years or not? And I think it boils down to this. He says, well, this is absurd. If your ability to bring the complaint within time or not is going to depend on the happenstance, whether some other person who no longer actually has any practical interest in any of this anyway, and it's their state of knowledge which is going to make all the difference to the jurisdiction of the Ombudsman. Now, that's why I suggest that actually if they have no interest in it, it may be on your case that actually you're not subject to a 3-year time limit. You can take as long as you like, because you say, even though we knew, that bloke didn't know, so time hasn't begun to run against us. Is that right?
Well, that raises a number of points on which we would respectfully differ with the way your lordship put the scenario.
Right.
So, in respect of whether any particular PPI was missold, we don't know what happened at the point of sale. We can perhaps make inferences. We can, and I can say this, the official receiver, with the approach of the time limit, looked at everything it possibly could to try and identify in what circumstances PPI might have been missold. For instance, if people had secured loans of various sorts, or that banks had claimed in the insolvency. But it was there are separate questions which you can imagine were addressed to some greater degree below, because they turned into factual questions about what should the official receiver have done, in what circumstances does the official receiver require awareness if he does things, or even if he doesn't things but he should have done things, and what are the level of the obligations on the official receiver. One can see the panoply of questions that potentially arise. But we therefore say that if there is information which is sufficient to show awareness, that is set time running, and if there isn't, from the official receiver's perspective, there's no unfairness if there isn't. It's just the fact. And I say it arises to a degree out of the nature of the relationship. Now, there might have been many different ways which the legislature could have chosen to address this, with a much more sophisticated regime, both as to what authorization meant or what limitation meant in different ways. But to go back to the questions that were asked earlier, one can see the example. If it was said that the bankruptcy started a wholly new time limit, regardless of what the bankrupt knew beforehand, that would seem fundamentally wrong. So in that situation, there is a total absurdity. If there has to be a switch because of the bankruptcies regarding the complainant as solely the official receiver. And then if it's not solely the official receiver and you're faced with two potential people to investigate, which one do you investigate? Now, one may say the legislative choice that was made was imperfect. It's compounded, potentially, by the fact there is no backstop. There is no general backstop in DIS. There is the specific backstop for PPI, but that was introduced specifically because PPI had been going on for many years and continued to be a matter of major public concern.
Yes. I was going to ask you, if I may, about the backstop and what its relevance is to the issue we have to decide. I suppose it could be said that it's a double-edged point, because on one view, it could be said it can't be relevant to the construction issue that we have to determine, because that's the time limit provision you've shown us in 2.8.2 is a general one, as I understand it. So the fact that there's a long stop in a particular context doesn't necessarily provide help in answering what the general limitation provision means. But on the other hand, could it be said, on the other hand, that where the legislator found that there was a mischief which needed to be addressed, then it was able to and did act. And so it did enact a long stop in this particular context. And so if otherwise, the limitation provision does appear to be, unfortunately, not necessarily indefinite, but at least open-ended to some extent, then I think you would say, well, the solution is within the province of the legislator, which can act as it did in this context.
Well, I respectfully agree with both your lordship's observations. So first, that there is an element of double edge to it. But secondly, we do say that there is a specific legislative choice was taken here, but not taken lightly, if I can put it that way. I've already addressed the court on the fact that in order for that to be just, I say this in general terms, it was necessary to put in place an advertising programme that led to an enormous number of further complaints being put in. Put aside the official receiver, an enormous number of individuals put in further complaints, and it's in the submissions and the evidence. This has been the most extraordinarily large-scale consumer redress exercise. The FCA is the biggest in history, and it's gone on right to the end. And no doubt, were it not for the introduction of the backstop, it could have carried on for longer.
But on your construction, take PPI out of it. If the complainant is the consumer and never gains actual or constructive knowledge, time could run forever without the backstop.
There is no backstop.
And you would say that's a decision on its face. They were looking at the Limitation Act. There's no Section 14B equivalent here. And there's nothing offensive about it when you understand the underlying policy being a consumer-friendly environment.
My lady, yes, with great respect, we do say that perhaps in other contexts that might have been a surprising conclusion, that there is a bespoke limitation regime has been created for DIS. There was not an attempt to import, which could have been done, a limitation scheme based on the general limitation acts which have existed for hundreds of years. that bespoke regime was chosen to be in fairly short form, and for the reasons that I have already endeavoured to address you on this morning, it focused primarily, but understandably, on the position of the underlying complainant. And the question is, to what extent does that remain, if you like, the driving force of that, with the consequences that there may be anomalies at the edges? Or to what extent do you consider you need to reach a different conclusion? But as I say, I do stress the fact here, to give the example of the complainants who bought PPI 10 years ago and you find out 4 years ago, when it comes to the limitation period, he's gone bankrupt. The 10th year since the PPI was missold to him. Is the complainant the trustee in bankruptcy, or is it the underlying complainant? We respectfully say the answer has to be, it's the underlying complainant, the eligible complainant himself.
And the consequence of that is, in the case of death, if the consumer dies without being actually or constructively aware, PRs, even if they know to the letter that they have a complaint, are not subject to a time limit.
That, as I say, we're focusing on bankruptcy here, and there may be other answers there, but the short answer is certainly in the bankruptcy context, we say that...
No, I'd like you to focus on the death context, because we have to construe the rule, and the rule is the same rule for death, bankruptcy, incapacity, and agency. And I don't think it's possible to understand how the rule can be coherently and sensibly interpreted without looking at the death case, which I personally find a much easier case to get hold of, because in the death case it's much more stark. Because if someone dies without having become aware, then they will never become aware. And that's inevitable.
And in that respect, as I said at the edges, there may be anomalies. If that is the consequence, maybe there's questions that could arise as to some sort of constructive awareness. But I'm not suggesting that now. Here, the fact is, and it may well be the case, it's not just a possibility, it could be in many cases, when somebody died, they simply weren't aware. In principle, in the context of a consumer-friendly regime, why can't a choice be taken that, well, that's it, because why should the personal representatives be able to answer all those questions in Appendix 3? They can't. How do they know?
What is the purpose behind the time bar in 2.8.2?
Well, the purpose is most readily identified by reference to the underlying complainant. It is to place a time limit, well, a series of time limits, in fact, because there's the 6 months to respond, there's the 6 years backstop, and then the tail piece, if you like, is if there's lack of awareness in the form that's identified. But that's, dare I say, I mean, it's right front and centre of this debate because of the unusual features of PPI. Many individuals barely knew they had PPI at all, let alone what might have been said in the contracts or said to them. They've got no memory, they've got no document. So we're focusing on the tail end of the provision here, rather than the central focus, which rather assumes, in most situations, that you'll have a good idea early-ish on. Now, to the extent that the legislation put in place has been tested to its limits in this situation, one can see the response, and this adopts what my Lord Justice Singh said. The response to the FCA is to introduce a specific solution to that for the purposes of PPI, rather than fundamentally try to re-engineer the position on limitation. Because, to add to this, of course, it's a given that PPI was, in terms of the mis-selling, it was a problem 10, 15, 20 years ago. That backstop is, we respectfully say, almost entirely concerned with the effect of the extended limitation in 2.8.2, and it's a specific consequence of the feature of PPI, therefore led to that backstop being introduced. It might be said as well that in terms of the moral calculus, if one can see that up until the last moment, very, very large numbers of individuals were finding that they had PPI, that's not so surprising that, as with the anomalous position of trustees to bankruptcy or personal representatives, doesn't perhaps get the focus which it's been getting on the specific features of this application.
Right, now we had a number of questions for you, but you must make your submissions in the way that you think fit.
I was going to move on to the role of the OR as trustee in bankruptcy.
Yes.
That was, I think, the fifth of my headings from this morning. And I'd stressed that one was sort of pausing to take stock, as it were, but there was more to come, and I'm afraid the more to come is now turning to the insolvency issues. As I say, we say the primary point of consideration for this court is in relation to DISC and how that works, but it obviously has to have an interface with other regimes. Without doubt, that's the case. And it's by no means suggested on behalf of the OR that the court can ignore insolvency law and the roles and duties of a trustee. Our submission perhaps comes to this: it would be the tail wagging the dog to see everything through the prism of technical insolvency law, when the form and structure of DISC give no warrant for that. They don't evince that sort of level of detailed consideration of the different regimes that may operate. Now, we've put our positive cases to the OR's role in our skeleton. I'm not going to go through all of that in detail, but I'll just pick up on some relevant statutes and case law, if I may. And first of all, turning to the authorities bundle. And within that, tab 3 and page 26. So this is the functions and status of official receivers. In addition to any functions conferred on him by this Act, a person holding the office of official receiver shall carry out such other functions as may from time to time be conferred on him by the Secretary of State. Paragraph 2. In the exercise of the functions of his office, a person holding the office of official receiver shall act under the general directions of the Secretary of State and shall also be an officer of the court in relation to which he exercises those functions. So that's the source of the mention I made this morning of the officer of the court. I don't need to show you 399. It's in the bundle, but it shows how official receivers are appointed. What I think I can do next is to turn to tab 14, page 285. And this is the Minotaur Data Systems case, which you've heard me mention already this morning. Now, by way of background, the official receiver brings many of the director's disqualification cases that are brought in the courts. And this was a postscript to a disqualification case. The case had been successful and the official receiver had claimed costs. And there was then an issue as to what the official receiver's recoverable costs, if any, were. And as was normal in the case, the official receiver hadn't used a solicitor. That's frequently the case in disqualification cases, because the official receiver has rights of audience and is able to deal with them. Also, the official receiver puts in reports. Now, That's enough by way of background. So the question focused on whether the official receiver could get costs. If you look at 287, just under the heading Law, you'll see that the Office of Official Receiver was created by the Bankruptcy Act 1883, its purpose being to have investigations into insolvencies carried out under the direction of the Secretary of State. Subsequent statutes enlarged and defined the official receiver's duties, and those included receiver, investigator, liquidator, etc. So that's a little bit by way of history, and it does explain to a degree how the officer of the court label comes about. It really was a position that they were officers of the court in a stronger sense, if you like, originally. Then at page 291, one sees an identification of some of the relevant features. The sidelined passage: the Office of Official Receiver is not a prerogative office under the Crown, nor is it made by statute a Crown office. It's a statutory office, but although it's generally occupied, we are told, by individuals who until their appointment been civil servants within the DTI, and although they continue by law to act at and under the direction of the Secretary of State, they cease from appointment to be civil servants in the proper sense of servants of the Crown employed in the business of government within, in this case, a Department of State. And later on, after the indented passage, as the holder of a statutory office, each official receiver is empowered to bring proceedings, including disqualification proceedings. And then slightly later on, in the same paragraph, an official receiver litigates not in his or her personal name, but as the official receiver, the definite article being appropriate, since in each case one such officer alone is ordinarily empowered to act. And there is an intelligible sense in which it can be said that it is the office and not the individual occupying it which possesses the right to litigate and conduct the proceedings. It's nevertheless the case that it is not, as far as I'm aware, a corporation's sole as such. It's simply an office, and when somebody ceases to hold that office, there's a procedure for anything vested in that person holding that office.
And in that respect, it does appear to be distinguishable in law from the Office of Secretary of State, which is a corporation's sole. So the analogy with them and Home Office may not be exact, but it probably doesn't matter in this context.
It doesn't, but it might in other cases. And moving back to tab 3, page 13, you'll have seen this referred to. This is section 291A. This says, first trustee in bankruptcy. On the making of a bankruptcy order, the official receiver becomes trustee of the bankrupt estate unless the court appoints another person under subsection 2. Now, pausing there, that provision has been in place since 2017, and what you don't have is the prior provisions. Nothing turns on those, but just for your awareness, under the original section 287, the OR was in most cases initially receiver and manager. It was his job to convene a meeting of creditors to appoint a trustee in bankruptcy. But if not, the OR would become the trustee in bankruptcy after a period. So that's why ultimately it doesn't matter, because in all the cases that you're looking at, the official receiver is the trustee in bankruptcy, but probably in many of them it was under the legislation which applied prior to the enactment of 291A. But
And the property only vests when he becomes trustee.
and the property only vests when he becomes trustee.
So there's a timing point, but it doesn't affect the...
It's not a timing point on which I'm placing any reliance. Now, those are the only provisions specific to the OR which are of relevance to mention. And going back to what I said right at the outset, this is not a case which turns on any specific characteristic of my client as the OR. So the concept of trustee in bankruptcy is, of course, a label for a particular set of rights and responsibilities created by the Insolvency Act 1986 and its predecessors. I can take you next to page 15. That's section 305, which is headed General Functions of Trustee. This chapter applies in relation to any bankruptcy where either the appointment of a person as trustee takes effect or the official receiver becomes trustee of a bankrupt estate. The difference between appointment and becomes is simply because the official receiver would automatically become and didn't require an appointment. I suspect that's where the language distinction comes there, because of course many bankruptcies will have a private insolvency practitioner as the trustee in bankruptcy. Perhaps I can put it this way. You could, I think with some justification, regard the official receiver as the default trustee in bankruptcy, because private trustees in bankruptcy tend not to want to take appointments in cases where the estate is very small and it's not economic for them to take the appointment. So certainly in the case of very small consumer bankruptcies, of which there are many, one would almost universally find the official receiver as the trustee in bankruptcy. Then in subsection 2, the function of the trustee is to get in, realise and distribute the bankrupt estate in accordance with the following provisions of this chapter. And in the carrying out of that function in the management of the bankrupt estate, the trustee is entitled, subject to those provisions, to use his own discretion. The latter part of that had some relevance below on the question of what things a trustee in bankruptcy should or should not do, but again for today that doesn't matter. And then in subsection 4, just confirmation, the official name of the trustee shall be the trustee of the estate of X bankrupt, but he may be referred to as the trustee in bankruptcy of the particular bankrupt. Then moving to page 18. This is the provision as to vesting. The bankrupt's estate shall vest in the trustee immediately on his appointment taking effect, or in the case of the official receiver, on his becoming trustee. Where any property which is or is to be comprised in the bankrupt's estate vests, it shall so vest without any conveyance, assignment, or transfer. So if there is property, one doesn't need to worry as to whether it was assigned or not, or transferred or not. It simply happens by virtue of the statute.
I hope you don't if I could just ask, where are we heading with this? With this very helpful explanation. What's the when you say that the interface is relevant?
The interface is relevant because there are debates as to what the consequences of vesting are and what it is that vests.
Yes. And
to investigate those properly, I need to show the court the statutory architecture. Obviously, if it's familiar, I don't want to do it slower.
But your headline position is going to be, at the end of this exercise?
The headline position is going to be that what vests in the official receiver includes the right to redress.
But not the right to claim.
Because that's a contingent interest incidental to PPI, but not, to use inverted commas, a right to claim. Because that is not of such a character as of itself to be a form of property within the meaning of the Act. I stress that because obviously there's common law property, but then there's Insolvency Act 1986 property. So that's the direction of travel, my lady.
Thank you very much.
What the bankrupt estate is defined as is found on page 9. And that's section 283, and for current purposes, section 283, subsection 1. Subject as follows: a bankrupt estate for the purposes of any of this group of parts comprises A. all property belonging to or vested in the bankrupt at the commencement of the bankruptcy, and B. any property which by virtue of any of the following provisions of this part, I don't believe there's anything that falls into that category, is comprised in that estate or is treated as falling within the preceding paragraph. And then there's an exception for what in shorthand terms are called tools of trade thereafter. That doesn't have any relevance for our purposes. That then takes us to the final relevant provision of the Insolvency Act, which is section 436, which is found at page 30. And this is a general definition section within the Insolvency Act. But towards the top of the page, you'll see property, and this is a long-standing definition. Property includes money, goods, things in action, land, and every description of property wherever situated, and also obligations and every description of interest, whether present or future or vested or contingent, arising out of or incidental to property. And that has been said, and I don't need to show you the case, but it was in the Powdrill decision. It's hard to think of a wider definition of property.
Yes.
And we don't demur from that. It's also been said, or perhaps noted, that there's an element of circularity within the definition.
Yes.
But having noted that, that's what it is, and nobody sought to change it.
Yes, well, that's not unknown to the law.
Sorry.
It's not unknown to the law.
No, my lord.
Income tax is a tax on income.
My lord, indeed. Famously has been for a long time. So it goes wider than the common law meaning of property. We inserted in the bundle, not because it's determinative on this, but possibly because the section 436 draws on some sort of common law concept of property. It must do in order to have the extended definition, but we've included Ainsworth, which the court will be well familiar with. I can perhaps show you very, very briefly the relevant passage in what's otherwise a very long and, for our purposes, not relevant decision, and that's at it's tab 7, page 176.
Deserted wives' equity.
It's the deserted wives' equity, indeed, and therefore is really a historical footnote in many ways now. But Lord Wilberforce, again, I've referred to as something that he said pithily earlier. It's to similar effect at the bottom of 176. Having been trying to address the nature of this equity that was being argued for, he said, on any division, then, which is to be made between property rights on the one hand and personal rights on the other hand, however broad or penumbral the separating bound between these two kinds of rights may be, there can be little doubt where the wife's rights fall. Before a right or an interest can be admitted into the category of property, or a right affecting property, it must be definable, identifiable by third parties, capable in its nature of assumption by third parties, and have some degree of permanence or stability. The wife's right has none of these qualities. It is characterised by the reverse of them. So, topped and tailed by references to the particular issues in that case, which is a sort of a footnote in legal history now. But those four elements are regularly cited even now as being helpful. Now, as regards that, we would draw your attention to capable in its nature of assumption by third parties.
Yes.
On a similar note, also like to show you Deere and Reeves, which is found at tab 17 of the authorities bundle. And in that, it's page 336. This was a case concerning whether a power of preemption could be property. And the critical feature in the case, we respectfully say, was that third element. And if you look at paragraph 40 on that page, a distinguishing feature of a right of property in contrast to a purely personal right is that it's transferable. It may be enforced by somebody other than the particular person whom the right was initially vested. This right of preemption has this feature, it's expressly made assignable by clause 4 of the deed. It's true that it may be difficult to put a value on it, as the grantor may never decide to sell the property. But it's not necessary for a right to have any present or immediate value for it to be property within section 463. The relevant question is whether it is in its legal nature property. And you also made the the point, this is Lord Justice Mummery, the very fact that the parties were in dispute about it was suggestive of the fact that it had some value. But that point about transferability or assignability is what I was
Yes.
referring to.
You're probably going to come back to this, but can I just flag up to you a question that you'll need to assist me with in due course? I can understand the submission that it's inherent in the concept of something being property that it must have the quality of being transferable. If that's the submission, I can understand that. But the statutory definition, as you've shown us, is not confined to property. And you very helpfully showed us the words, for example, incidental to. And I am wondering in my own mind whether the right to complain under the FOS scheme could be regarded as being a right which is incidental to property, even if it were not transferable.
Well, Your Lordship has identified one of the matters I do need to address you on.
Thank you.
But in short, we say that it's not necessary to stretch Section 436 that far, because if the redress is incidental to property when it arises, it's contingent. And of course, to go back to what we were discussing this morning, it's a very unusual situation because it is not in itself a cause of action, albeit it may overlap with one. When an award is made, it's not something that you can see you were bound to get because of an existing cause of action, thing in action, because it depends on a discretion which is exercised by the Ombudsman to do what is fair in the circumstances, and the award may include things which aren't recoverable in any way at law, and that can be seen as an incident of the underlying insurance policy. But when one looks at how DISP is structured, what DISP has created is, and it may be regarded as anomalous compared to what could have been done elsewhere, but it's created a situation where it's identified an eligible complainant who can refer a complaint. The status of that eligible complainant is something personal to him or her. So that status, we would respectfully say, can't itself be a piece of property. And the process that thereafter happens is a process which is about that eligible complainant. That doesn't matter because the way that Section 436 is drafted is to say that things which are contingent on the insurance policy, to use our facts, are sufficient. And that's a contingency which, when it arises, the right to the redress itself is captured. And certainly there's no sign in the authorities, for instance, Ward is relied on, just simply to say, well, the right to complain must be some form of property itself. Well, within that wider definition in 436. And we respectfully say that it hasn't descended to that level of analysis that we've had to in this case, which is to address, well, precisely what does DISP create? And that's the difficult thing to grapple with. And would respectfully say that is not something itself which is incidental within the meaning of Section 436. Because it is the insurance that we focus on. One can readily see, though, that if this process is followed through, as the eligible complainant under DISP is able to, eligible complainant defined in the way we talked about this morning, then when redress arises, that's a perfectly sensible use of incidental to. We respectfully say it's a big stretch to say the personal status or characteristics, which is how DISP 2.7.2 works, somehow represents something incidental to an insurance policy.
Can I be sure I understand why this matters? It's your own case, it must be, that the OR, as trustee in bankruptcy of bankrupt estates, is entitled, by virtue of 2.7.2, to complain to the firm and then to the Ombudsman. And it's your own case that if such a complaint is successful and an award is made, you get the money. And I assume it's your case where the rules, or rather I think the Act, gives the complainant the right to choose whether to accept or reject the award. That, again, is a matter for the OR if an award is made. You wouldn't want to have the bankrupt out of spite saying, well, I can see the OR's secured this money, but I'm going to reject the award because I don't want to.
The bankrupt would have to comply with directions from the official receiver in relation to, if there was not a piece of property maturing by its contingency ceasing to be contingent, that then vests.
Yes. Okay, leave that on one side. So what practical difference is there between your case, which is the ability, I won't say right, but the ability to refer a complaint to the Ombudsman is in your hands, and the award, if made, is in your hands, and the alternative, which is the right to complain, is a piece of property which vests in you. What difference does it make? Because on either view, you're the person who writes the letter.
The short answer is we have attempted to analyse, the official receiver attempted to analyse what structure DISP creates and to address the court on what they consider, the official receiver considers, the structure to be created. Now there's a separate point which my friend makes, that if this is something which vests the right to complain, vests in the official receiver, he relies on that to say, well, that must feed into the way you interpret 2.8.2R, because he says it's clearly, at the very least, consistent with, if not supportive of, my submission that in those circumstances the complainant is the person who is entitled.
Because it's their claim.
Because it's their claim. Because it's
and you want to draw a distinction between it being your claim after bankruptcy, which makes it easier to say it's your knowledge that's awareness, which is important, and your right under the rules to bring the eligible complainant's claim, which you say still remains the eligible complainant's claim, even though you've got a right under the rules to bring it.
And the reason we say that, my lord, is that we start by trying to interpret what the draftsman of DISP, draft person of DISP, was seeking to achieve, and that is then what has to be interrogated by reference to the insolvency legislation to see, well, what is the insolvency legislation consequence of that?
Thank you.
You rely on the third of the fourth Ainsworth factors in particular. You say the right to complain is not something capable of assumption by a third party.
We do, my lady, because one's seen in DISP.
The third party here is not the official receiver. When in Ainsworth terms, the third party has to be somebody at arm's length, so to speak.
That's right. Here we say that this is not something which is of its nature transmissible. It's a personal status. And we do emphasise that as being at the heart of the way DISP has been drafted.
And indeed, there's one specific provision in subparagraph 6 of the definition of eligible complaint in which an assignee can become an eligible complainant if they are a successor to interests in a policy. But you presumably say, well, that points up that in other cases you can't become an eligible complainant.
My lord, yes, we've sought to take this as it is and work out what the consequences of that are. Now, there was some debate below about whether, for instance, this right to complain was something assignable that was raised by the judge. The short answer is it's very hard to prove the negative, but we're not aware at all of that ever having been done. Where claims management companies are involved, claims are made by the eligible complainants, not by the claims management companies. They insert themselves and have a relationship, and they charge fees, but they don't take assignments of any rights.
Yeah. Well, irrespective of what may or may not happen in practice, although that is helpful to know about, your fundamental submission is that conceptually, as a matter of law, it's not capable of being sold, for example.
We do say, and I repeat myself obviously, but the status of eligible complainant, which is the way it's drafted here, is of itself intrinsically not something that falls within property in its common law sense, and nor does it fall within the extended definition, which is the important thing.
Yes.
But that doesn't matter for the purposes of the official receiver, because there is a contingent right to the redress if redress is awarded. And I should add, just to be fair, I think my friend has referred to this in a skeleton argument on the question of assignability. I think it's put by them that there might be difficulties with it, but they have no formal position on the point.
I see.
But no doubt my friend can address you further on that if required. So I was next going to go to the Aerst case, which is at tab 8. It starts at 192, but I think we can pick it up on page 203. And this time we're within the speech of Lord Diplock.
Yes.
And it's the sideline passage. Another example which owes its origin to statute is to be found in the law of bankruptcy, which owes its origin... I'm sorry.
Another example of what?
I should say. Another example of the concept of legal ownership of property which didn't carry with it the right of the owner to enjoy the fruits of or dispose of it for his own benefit, which is the start of the long paragraph beginning of 202. Bottom of 202. So there's a contradistinction, if you like, with the more general trust situation that he described earlier in the paragraph. Maybe simplest if I simply let the court read the sideline passage.
No, I think another example, strictly speaking, is an example of what he's referring to at the top of that page at A. Just because you can't identify some other beneficiary doesn't mean that you're the beneficial owner.
Yes.
Because an estate in the course of administration
Doesn't have any beneficiaries.
it doesn't have any beneficiaries, because until you've gone through the process of administration, there's no identifiable property that anybody can claim an interest in. And that's the Commissioner of Stamp Duty's case.
Yeah.
But that doesn't mean the executors are themselves the beneficial owners.
No.
Yeah, so that's the first example.
And then he says bankrupt is another example.
Yeah.
In the course of administration, no creditor can claim any interest in any particular part of the estate. What they have is a right to prove and qualify for a dividend if there is money available.
It's similar to the right of due administration in relation to the estate.
Yes.
So what we say though is that what's intended in this concept of trustee in bankruptcy as described is using the word trustee to indicate that beneficial ownership is not vested in somebody, cannot enjoy the fruits of it himself or dispose of it for his benefit. And he says it's no misuse of language to describe the property as being held by the trustee on a statutory trust if the qualifying adjective statutory is understood as indicating that the trust does not bear all the indicia which characterise a trust as it was recognised by the Court of Chancery apart from statute.
Right.
And the other case I was going to refer to is a decision of Mr. Justice Charles, which is found at tab 24, page 515. This was a family claim. I don't think the facts are of particular relevance. What he does, and it reflects what my Lord Justice Nugee was just mentioning, 28 refers to statutory vesting covering beneficial interests and shares. The result is the trustee in bankruptcy holds those assets and their product for that purpose. And if and when there is a surplus, he holds out in trust for the purpose of giving effect to the bankrupt's entitlement to the surplus. The effect of that combination is that the bankrupt has an interest in the surplus that he can deal with. The surplus is identified as and when all debts, interests and costs have been paid. Until then, the trustee in bankruptcy holds the estate of the bankrupt and its product to perform his statutory task, so effectively on a purpose trust. It follows that any dealings of the bankrupt with the surplus crystallises when it is identified, and before that the trustee in bankruptcy can deal with the assets vested in him and their products as he thinks fit in the performance of his statutory duty.
Mr. Gibbon, would I be right in thinking, therefore, that although the primary fiduciary duties which are owed by the trustee in bankruptcy are those owed to the creditors, that nevertheless there is some, is this right, there's some residual fiduciary relationship with the bankrupt person?
There is a residual relationship, yes, because albeit it's unusual, a bankruptcy can have been simply a cash flow bankruptcy.
Right.
And it might be the case that the trustee is able to realise substantial assets which discharge all liabilities, and then the property surplus will go to the beneficiary, who in that case will be the original bankrupt.
So to that extent, and it may be perhaps theoretical in many practical contexts, not least because the value of the estate may not be very high, but nevertheless conceptually, would it be right to think that it's not the case that the bankrupt has no interest in how the official receiver behaves?
And my Lord, I would respectfully adopt that. In fact, that was a submission that I did make below. I haven't sought to press it because obviously in many cases that won't be a realistic possibility, but it certainly is a possibility, and it's not unknown. So it might be some way down the line, and it certainly won't allow the bankrupt to tell the official receiver what to do in any way. He's got the right under section 303 to make an application to the court in relation to, strays off piece now, but section 303 to make an application to the court in respect of the trustee's conduct of the bankruptcy. But that's a separate point.
Yes.
I thought you said this morning that on your case, even though the bankrupt, the OR, has a right under Rule 2.7.2 to bring a claim on behalf of the bankrupt, the claim is still the bankrupt's claim, and the bankrupt himself can still bring a claim.
Yes.
That seems a little bit odd in circumstances where the trustee will get the award. You would have thought the trustee would be able to stop the bankrupt from interfering in the OR's decision, the trustee's decision as to how best to prosecute this claim for the benefit of the estate.
Now, the answer to that isn't a one-word answer, but in essence, your Lordship has identified a concern to the official receiver. The official receiver has sought to tell financial institutions in the past, please deal with us where there is a bankruptcy. However, the official official receiver's understanding is that, again, going back to the nature of the right created here, there is nothing on the face of DISP to prevent that individual referring the matter, him or herself, to the financial institution. And obviously, if redress is created, then the ward situation comes in. The official receiver didn't know the individual had applied to the financial institution there, but it was made aware of it and said, well, that should clearly fall into the bankruptcy because it's that property, that award vests. But that's a separate question to whether the law prevents the bankrupt referring the matter, and we say it doesn't. And I do respectfully say that is, again, consistent with the way we say the provisions read together holistically do work. Namely that if the bankrupt is entitled to make that reference, it's perfectly sensible to regard him as the complainant within 2.8.2.
Right, so that was KK.
So that, just to show you where we are on the roadmap, that gets me to the end of what was my 5.
Yes.
And my 6 is how the OR says that the role dovetails, the role of trustee in bankruptcy dovetails with the drafting of DISP. And to a degree, obviously, some of what I'm going to say I will have dealt with already, so I'll try and take that quickly rather than repeat myself.
Yes.
So we come back to DISP. It's common ground that the draftsperson of DISP 2.7.2R considered that a trustee in bankruptcy could bring a complaint on behalf of an eligible complainant within the meaning of that provision. And a pertinent question to ask is, to what extent did that draftsperson take a technical view of insolvency legislation when he drafted or she drafted in the way that they did? And we have to make inferences based on the words used. And as again you've heard me say, for reasons already given, a clear drafting choice was made which defined the eligible complainant as the underlying customer in 2.7.2. And that was a status, or if you like, simply a description, which was unaffected by intervening incapacity or the appointment, just in the same way as it wasn't affected by the appointment of an agent. Equally clearly, the differing mechanisms that might apply in situations of loss, I use this in a general phrase, loss of capacity, indicates that technical detail seems to have been a matter of indifference to the draftsperson. They are all lumped together as authorised by law. And I've made this point perhaps already, but the use of the word authorise, rather than any technical investigation, may simply be drafting symmetry. It seemed to do what the draftsman had in mind. Convenient borrowing, if you like, for conciseness. I'd further suggest that there is perhaps an indication here of a much more general point as regards bankruptcy, which is that the drafting evinces an assumption on the part of the draftsperson that in the event that any redress was payable, then it will form part of the bankruptcy estate. And I say it evinces that assumption because for the trustee in bankruptcy to be authorised by law, one assumes that if it wasn't going to vest in the trustee in bankruptcy, there's no obvious reason why the trustee in bankruptcy would be authorised by law. So, two sides of one coin. Now, we simply have to work with the drafting we have. We don't have the subjective views, and they wouldn't be a relevant matter anyway. We say that the assumption made that something would vest is correct, and further, there's no obstacle in insolvency law to giving effect to that, while nevertheless, and this is the important thing, respecting the fact that the status of eligible complainant is just that and is not in itself transmissible. And the court knows this is a place where we part company with Shop Direct. We were asked by the judge to put in, both sides were asked to put in submissions on what vested, and I perhaps should show you those very briefly so that you know where they are. And that's in the supplementary bundle. At tab 9, page 171. These are the official receivers. Submissions. So there were particular questions posed by the judge in the course of argument, which parties were given a chance to answer overnight before the last day. I needn't trouble you with one. There's a question, is there any meaningful sense of trust? And you see our answer there with reference to Aston, KK and MA. And picking up on another question, this is the section 303 reference. Other than the right to apply to court for directions, what rights, if any, does the bankrupt have against his trustee in bankruptcy? And there's a little bit of extra detail which your lordship may find of relevance as to what may come the way of the bankrupt in due course. As you glance over the answer to 2A. And then I can go straight to 5. And 173 are the principal parts. And this is in response to the question, what specifically is the piece of property that vested from bankruptcy? Invite you to cast your eyes across that because it ties in with the recent exchange. Now, pausing there, it is not the official receiver's case, doesn't have a positive case on whether the draftsperson necessarily identified from precisely what mechanism the trustee gains that authorised by law status in a disc sense and how the mechanism worked. And we say for this purpose, for the interpretation of disc, it's only necessary to know that the draftsperson's assumption is not falsified by insolvency law. So clearly, if this had misfired, to refer to a phrase I think used in Noakes many years ago, and the trustee in bankruptcy, for whatever reason, simply had no capacity, no power that could be described under any use of the word authorised, then plainly this court, we'd respectfully say, would be bound to say so. But on our primary submission, if it can be seen that there is property which gives the trustee the status to be authorised by law within the meaning of DISP 2.7.2, that is sufficient, we respectfully say, for the analysis. And it's only to that extent and no further that it's necessary to consider the technical insolvency position. Now, it's then, perhaps at this point, one talks about the words on behalf of.
Just before you move on to
Well,
that,
yes.
can I just ask you about, going back to the definition of property
Yes.
in section 436, which is at page 30 of the bundle of authorities. I'm just wondering in my own mind whether we need to keep in mind the distinction between contingent and incidental. Because, correct me if I'm wrong, what you've been submitting, and I think this is what you said in writing to the trial judge, is that the future right to the redress, if the complaint is ultimately successful, is incidental to property. And so you drew a contrast between that, as I understand it, and the right to make a complaint,
Yes.
which you say is not incidental to property. But could it be said that the future right to redress actually falls more naturally into the concept of contingent?
If I haven't made myself a bit clear, then apologies, but we do say that right to redress is contingent.
Yes, you do. Well, if that's right, let's say that the right... You okay?
Yes, I'm sorry. No, I'm fine, thank you.
If the right to redress ultimately can be properly categorised as contingent to property, then why can't the right to make a complaint in order to secure that redress be regarded as being incidental to that contingent property? What do you want to think about that?
Well, the way we would respectfully read that provision is that it's an interest contingent or incidental to property,
Yes.
property being the underlying
Money.
insurance contract, but your lordship's suggesting a sort of double property.
Yes, I'm just trying to find an example of something which is incidental to, but is not contingent, because clearly Parliament has enacted this very broad provision to mean something. It doesn't use words unnecessarily. So it has words like present or future. I understand that, vested or contingent, so I can see what that's getting at, I think. And so I'm asking myself, well, what does it mean by incidental to? And at the moment, I'm afraid I'm not understanding why the right to bring a complaint in order to secure redress in the future, it can't be regarded on the natural meaning of this phrase as being incidental to property.
The point we'd respectfully make is if you focus first on the underlying property being the policy, the PPI, then the mis-selling of that can be pursued because of DISP 2.7. DISP 2.7 does not itself create a property right. There is no right to...
Well, even the final redress.
But the final redress arise out of, contingent or incidental to property, but we say it is a stage too far in the light of the drafting of DISP to say that takes away what is described as a personal status for the eligible complainant. So it's trying to make sense of how the two fit together. And one's not driven to take section 436 that far if you can latch on to the redress, right to redress when it's awarded.
Right, okay. Well, I understand the submission. Sorry, I've taken you out of turn.
Sorry.
No, not at all. I also have an eye on the clock. I don't want to put any pressure on anyone at all because you must make your submissions as you think fit. But my sense is that I think you're on 6 of your 7 points now, and you're fairly close to the end. Is that?
I'm fairly close. Yes, I'm slightly less far ahead than I'd anticipated, but I think that's been a useful exercise. I'd hope the interchanges with the court have
we
illuminated somewhat the position that
we certainly find it helpful.
I'm obliged, my lord. I was going to go on next to the question of on behalf of, and there's a little bit of debate in the skeletons about what one should draw in relation to that. We respectfully said the authorities make clear that there is no fixed meaning to on behalf of. It's a point I can take relatively quickly. I hope. At tab 23 of the authorities bundle is the Rochdale case, and within that, let's show you first. There was a provision concerning whether water charges could be charged to tenants as part of the local authority's provision to them. It's a rather oversimplified description, but one sees where the phrase was found in paragraph 10.
Sorry, page?
Page 484, my lady. And it's the second half of that indented sub-paragraph. The powers of a local authority under that act shall be deemed to include power to enter into an agreement for the collection and recovery by the authority on behalf of any water undertaker or sewerage undertaker of any charges fixed by the undertaker. So that was the context in which the words on behalf of were found. The observations are fairly general. And if you turn to page 496, there's a passage which is sidelined there. I think it will be simplest if I simply ask the court to read the sidelined words through to letter E on 1354.
Mr. Gibbon, speaking for myself only, I sometimes wonder whether in the law we always try to find some other phrase to replace the phrase that's being used. I mean, why doesn't on behalf of just mean on behalf of?
My Lord, with respect, your Lordship makes a very good point, and I was certainly going to say, because I've scribbled this in my margin, the search for synonyms is one which should be undertaken with caution.
I mean, sometimes it's necessary.
Yes.
Of course, I understand that. I'm not being flippant.
Yes.
But clearly, as this and other cases make clear, it does depend on the context in which it's being used. Sometimes it'll mean instead of. Sometimes it'll mean for the benefit of or in the interest of. But that's not really the flavour that we have here, because, as we know, the trustee in bankruptcy is there principally to bring in the property for the benefit of the creditors. So it all depends on the context, doesn't it? I think your simple point is that in this context, it's sufficient that the trustee in bankruptcy is authorised by law to bring a complaint on behalf of the bankrupt person. That doesn't require detailed analysis. I'm not saying I agree with you, but you say that doesn't require any detailed analysis of insolvency.
Right, well, that is our primary point. The other thing that we were going to raise in relation to this was, to the extent that synonyms can be helpful, then we considered the word for, which was used in 50, captured the right level of flexibility and generality. This isn't a case where, for instance, it's clearly an agency and only an agency that's being discussed. I was going to go on to refer to the Plevin case, which did focus on and on behalf of in an agency sense. I should show you that briefly.
Just before we move away from this, when you say for might capture it, that's not for in the sense of for the benefit of, because my lord says the benefit is for the creditor.
And it shows why I need to be so careful in putting these things forward. It might capture it, but it doesn't. It's not the same words. The right words are on behalf of, is what they mean in context.
Your point is the trustee can bring the complainant's complaint, but it's still the complainant's complaint.
Yes.
That's really what you want to say.
But I do have to address it because it has been a matter of some debate in the course of both the hearing below and to a degree in the course of the skeletons.
Yes, and we need to bear in mind what Lord Sumption said in Plevin.
Yes. So I should show you Plevin quickly. That's Authorities tab 29, but within that page 600. And simplest probably if I ask you to read the sidelined passage in paragraph 30, but also the first couple of sentences in paragraph 31 as well.
Thank you.
And one very short point on the back of that passage is that we say that legislation here, which was concerned with making somebody liable for the actions of somebody else, well, that was the submission, did the legislation have that effect, is very different to a situation such as we have here, which is whether a complaint can be put in on behalf of somebody else. An access provision, but it's an access provision in context of the scheme having been put in place for the benefit of customers, etc. So that was the simple short point in relation to that. But again, it comes back to how do these words get construed in context. Before leaving this part of the official receiver's primary case, there are just two things I should show. It is a matter of duty to the court as much as anything else, and that's on the question of contingency. In tab 12, there is the Campbell case, which is found at page 260.
Is this the CICB?
My lord, yes. 260. It starts at 258. So this was the case, as you'll recall, where Ms. Campbell suffered injury because of a criminal assault. She applied to the CICB for compensation. She was then adjudicated bankrupt, and subsequently an award was made in her favour. And it was held by Mr. Justice Knox that there was no way that that award would fall into the bankrupt estate because it didn't meet any of the definitions of property. There was no right to enforce an award. The prospect of getting an award was not a thing in action, etc. And it was a mere space or a hope of being awarded the award. And clearly, without going through the detail of it, he clearly regarded it as being a very hard case if that had been the result. But the reason I show it to you, it relates to some obiter comments that are made, because although the Campbell case is not something that we quarrel with, it's a matter of decision, there are some obiter comments which have been the subject of negative comments, and I should show you those. And that's on page 262, paragraph starting just above letter F. And he's trying to address what would be a contingent or a future interest, etc. The possibility of achieving an interest in something which presently does not exist but may exist in the future. He says examples might perhaps be the owner of a lottery ticket in relation to the prize that may, perhaps, at the end of the following week, arise in his or her possession. Similarly, the person who's filled in the coupon on the football pools might perhaps become entitled to property should that coupon have been successfully filled. In neither case, there can it be described as a future or contingent interest arising out of incidental to property, because there is no underlying existing property which, or the proceeds of which, are susceptible to the existence of a proprietary interest, even a future one. And he said that, as regards that, the trustees' argument could not succeed. Now, there was, of course, in this case, no underlying property for the reasons the judge gave, but we mention it because we say at the very least those remarks, as well as being obiter and non-binding, are either wrong or at the very least questionable. And we draw your attention to an observation of His Honour Judge Barker, sitting as a High Court judge in the Walden case, to that effect. And that's page 548.
I would have thought a lottery ticket contained contractual rights, which were rights of property. But
your Lordship essentially has the sort of concerns that the learned judge had in that case.
Yeah.
If I ask you to turn to page 558, paragraph 54. So, So I should say he makes no final decision because he doesn't have to, but we do respectfully draw those remarks to the Lordship's attention. And it has this relevance perhaps, which is that we say there's nothing in those obiter remarks in Campbell that should cause any question, we say, of the submissions we've made about the nature of the right in respect of redress in due course.
Yes, that's because, as I understand it, you say that here the relevant property is the policy.
We do, yes. Now, it's at that point I move to the last of my sections, so I do hope that I will actually finish before we adjourn for the day. And the heading we gave to this was, is the right to complain itself property, using metaphorical inverted commas around right to complain. The judge, of course, reached the conclusion, based on a detailed analysis of insolvency law, and this is where it comes in the sequence of our argument, in agreement with my learned friend, that the right to complain was itself property which vested. And we have sought to deal at paragraph 61 to 79 of our skeleton with what the judge said. And I'm not going to repeat all those, I'm simply going to highlight particular points. And we referred first to the judge's reliance on the Re case. That's at Authorities tab 11, page 244 in the Authorities bundle. Now, this was a case with unusual facts. They are sufficiently summarised in the head note, which I'll just take you through briefly, if I may. These were appeals by a bankrupt, R, against county court orders relating to fishing licences held by him. At the time of the bankruptcy order against him, R traded as the owner of 4 UK-registered fishing vessels. He held licences for them under the Sea Fish Conservation Act 1967. The vessels themselves vested in his trustee in bankruptcy. It was common ground that the licences did not. The effect of the bankruptcy order was to invalidate them. However, the Ministry of Agriculture, Fisheries and Food, by whom the licences were granted, recognised an entitlement, inverted commas, in R, or in any person in whose favour he might waive that entitlement, to be considered for the grant of fresh licences. That entitlement had a value. The question for the court was whether that entitlement should inure for the benefit of R's creditors or for the benefit of R. And the district judge decided in favour of the creditors. And the appeal was dismissed. To construe the Insolvency Act in a particular section 436 as excluding that recognised entitlement from his property would be contrary to the purposes of the Act. And once it was not excluded, and it wasn't excluded, then use of it by him would be inconsistent with the scheme. The court could not, merely from a consideration of the purposes of the Insolvency Act and non-exhaustive nature of the definition of property, could not conclude that any asset of the bankrupt which could be realised or turned to account was property within the meaning of the Act. So the mere fact that money might arise didn't necessarily make something property. The recognised entitlement of R as a previous owner of fishing vessels with an interest of a kind falling within the definition of property in section 436. It was a present interest incidental to property, i.e. the vessels. So it's an unusual case, and it's also clear from the decision that Mr. Justice Warner found elements of the analysis challenging. And within that, I ask you to turn to page 255. You'll see there, the point I just made is picked up just above letter D. The point about the non-exhaustive nature of property doesn't mean that everything that can be turned to account is property. I have, however, after considerable hesitation, come to the conclusion that Mr. Davis is entitled to succeed on one of his alternative arguments, which was that Mr. Ray's recognised entitlement came within the words in section 436, and every description of interest, whether present or future or vested or contingent, arising out of or incidental to property, namely his vessels. I think that the recognised entitlement is a present interest incidental to the vessels. The word interest is notoriously one of wide import, the meaning of which varies according to the context which it's used. Here it's not limited to an interest in property, the extent of interest arising out of or incidental to property. The The difficult question is whether the phrase every description of interest includes an interest which is not enforceable in a court of law, but which is nevertheless marketable and so capable of being turned into money. It refers to power drill, and he says the words every description of interest are fairly capable of bearing more than one meaning, etc. And he said it's right to give the meaning that gives effect to rather than frustrates the statutory purpose. But what one sees him grappling with there, and there is an element to which it arises here, is there are rolled up expressions within within section 436 that make analysis difficult at times.
I mean, correct me if I'm wrong, Mr. Gibbon, but the way I read that passage, Mr. Justice Warner appears to be saying that the issue he was addressing there was whether it was fatal that it could not be enforced in a court of law. And he says that they could be construed as meaning only interests capable of being asserted or defended in legal proceedings. But there is nothing in the words themselves to confine them to that. So that's the proposition he's rejecting. In passing, I note, he does say that the interest in that case was nonetheless marketable. Is that significant?
We do say that's significant, and it was the particular point I was going to highlight, because it was a curious feature that, albeit the license was something which disappeared on bankruptcy, I can give you the reference. Yes, it's page 248. Nevertheless, people were prepared to pay money in respect of licenses. That's a curious thing because, on the one hand, one's got to identify they're incidental to property, and yet the way that the value comes about, so it seems, is because there are finite numbers of licenses, and individuals who've got the benefit of licenses which are attached to particular boats, as it were, if they give up those licenses, they can give them up in favour of somebody. So it's got a value, therefore, because there is a finite supply of licenses. And that's dealt with on page 248, starting just after letter A.
So was it transmissible to a third party?
But it wasn't strictly transmissible as such. But, I mean, it again turns on the fact that the ministry recognised these nominations. There was a recognised practice in relation to that. So,
sorry, they are traded, in practice they're traded for value.
Well, these were traded for value, yes.
But not strictly in the sense of being bought and sold, because they're
But
not
not bought
assignable.
and sold, because...
But what happens is you lose your licence if you lose your boat, but you can give up your right to apply for a new licence to somebody else, and they'll pay you money for it. So
And there was a form, which you could fill in which said, I'm giving up my licence, I'd like to give it up in favour of X.
and the ministry would in practice, although not legally bound to do so, as I read it, would in practice give effect to that.
Yes. And of course, the relevance comes here because the trustee is trying to realise the value of the vessels. The vessels will be more valuable if they've still got the licence attached to them. So what the bankrupt was trying to do was keep for himself the value of the licences, whereas if attached to the vessels, as it were, and I say attached, it would require the bankrupt, the detail of this is in the decision, require the bankrupt to waive in favour of the purchaser from the trustee. So he's therefore got to take part in order to allow the vessels to be transferred with the benefit of the licence, albeit there's no transfer of the licence that's taken place. So it's a very curious set of circumstances. It's a very curious set of circumstances. But we respectfully do say that whatever parallels might be drawn, as I say, the vessels there we would say might be the one level, the equivalent of the insurance policy, there's no marketability, there's no characteristic, to use the judge's words, that enables or facilitates the economic convertibility of the right under DISP 2.7. So that remains a personal right of an eligible complainant, for reasons I've obviously discussed at some length in argument. And that, we say, whatever Ray shows us about the margins, and it was to say, Mr. Justice Warner found this a very difficult point, but whatever one sees about the margins in Ray, it was a critical element of that decision. There was a marketability to the interest, and he specifically says the mere fact that something might have a value, so obviously this award will have value in the hands of the trustee in bankruptcy if such an award is made. That of itself is not an answer to whether it's property.
Right.
And you'll have noted in our skeleton we said assignability would be an indicium. I've already addressed you on the position as to whether in fact there is assignability here. And I've referred to what my friend's submissions are on that, so I don't need to take that further. The next case I was going to touch on was Ward, which is found at tab 9, page 93. No, I've got something there. Sorry, it's page 543, tab 26. My apologies. And this head note is perhaps worth looking at just to make good the timing sequence I referred to earlier. On 23rd January 2012, Mr. Ward applied to the court seeking an order that the official receiver release certain monies to him. These sums constituted the balance of payments that had been made to the OR by Halifax in September 2011, and these payments were related to PPI policies taken out by W in respect of loans made to him by the bank sometime before 2009. W and his wife had successfully petitioned for their own bankruptcies in February 2009. At that time, some £15,000 was owing to the bank in respect of a loan. The OR was appointed as W's trustee in bankruptcy on 23rd July 2009. Both W and his wife were discharged early from bankruptcy on 3rd September 2009. Subsequently, W had complained to the Financial Ombudsman about the sale of the PPI policies to him, and it was this complaint that led to the payment made by the bank. W had no knowledge about the possibility of making such a complaint until the PPI mis-selling affair became public knowledge, and it was held that the payment from the bank fell within the definition of property as laid down in section 436 because it represented an interest incidental to property. The right to complain to the Financial Ombudsman arose out of the ownership of the policy, and therefore the payment received as a result of such complaint was an interest incidental to that property. Alternatively, the circumstances under which the PPI policy arose, PPI policy was sold to W conferred a cause of action upon him, and that cause of action could be viewed as property encompassed within the estate in accordance with the meaning of section 436. So it was a case where there was one counsel there for the official receiver. Mr. Ward wasn't represented, and one sees there, it's just too much to be read into it, but the fact that I mentioned this morning, that the eligible complainant, Mr. Ward, had made the complaint. There's no question, for instance, of somebody saying, well, the whole thing was a nullity because Mr. Ward had no entitlement to refer that complaint. One doesn't know what the thinking of Halifax was. I suspect it may have been as simple as we've decided there was mis-selling, we just need to make sure that somebody receives it. They'd obviously paid the first part to Mr. Ward himself, and I don't think history relates what exactly happened to that first payment. No doubt the official receiver would have sought to obtain it, one imagines. But the critical question, I suppose, is twofold. First, there's been no challenge to conclusion with the ratio of the case, which is that redress is part of the bankrupt estate, and we respectfully say the outcome is clearly correct. But what it doesn't seek to do as a decision is address in any detail the mechanism of the complaint process and DISP. It's an after-the-event analysis to determine what to do with the redress payment, which is the focus of the judge's concerns. And we've given reasons in our skeleton as to why that decision, to the extent it's inconsistent with the OR's case, should not be followed. But we pointed out, I draw this to your attention, one essential absurdity, which is that if the right to complain as complainant is what vests in the OR, there's a real question as to whether the OR would be able to make a complaint because the OR is not an eligible complainant. But that's a forensic point. It's a point about what we would say would be an absurdity of that situation. And on the question of what might be called the alternative or the fallback as to thing in action, just a few short points. There is no single definition of what a thing in action is. It can be understood narrowly as meaning something that can be solely pursued by action, or could be, but with some restriction. Or it can more widely be looked at as a residual category of property, which encompasses everything which is not in possession. And the parties have not either below or on this appeal sought to set before you extensive authority on what things in action are. And we simply respectfully, on this point, repeat the submission. There is no evidence to show that the DISP scheme gives rise to something which is capable of assignment or alienation as regard the process, which is begun by 2.7.2.
Were authorities like Ainsworth mentioned by the judge in this judgment?
We have what we have. It appears that the case was subject to some listing complications, and they're found on page 544. This is the only report of which I'm aware, and of course the judge himself cites provisions of the Insolvency Act, but there's no reference to what beyond that may have been referred to him. Mr. Mohyuddin is experienced counsel, now in Silk, and I'm sure he did his job correctly, but I can say beyond that no more. I was then next going to look briefly at Carr. And this is really for a simple point. We respectfully say consideration of the... I'll pause for your ladyship.
Thank you.
Just before we look at Clark, do I understand it? Your submission is that the right to bring a complaint under this is not a thing in action. Do you understand it to be the respondent's submission, but it is a thing in action?
I think my friend would say it's one possible analysis. I saw him nodding through the side of my glasses. But my friend will develop his submissions on that in due course.
Can I raise something else? The right to bring an action that damages for breach of statutory duty under section 138D or whatever it was would be a thing in action.
Without doubt, my lord.
Would the right to go to the Ombudsman, which you described earlier as a sort of ADR process, and as we saw earlier, is capable of settling that claim, would that be incidental to your right to sue for damages if it were coterminous? And I have your point, but they're not always coterminous, but they might, in some cases, be.
With respect, it depends on whether you're looking backwards or forwards, possibly to some extent, because if one's looking forward, let's look at it this way, rather than have the complications of res judicata, the fact that it is coterminous is, in a sense, neither here nor there, because you're not pursuing your right as an eligible complainant to seek compensation because of Section 138D. That's a parallel route that may exist. You are pursuing your right, if that's the right word to use for it, because you meet the requirements of.
So you say it's not incidental to your right to damages.
No.
It's a separate statutory right.
It's separate. So if Parliament had chosen either not to enact 138D at all, or alternatively, perhaps this might be a better example, had excluded from Section 138D things that could be brought before the Ombudsman under DISP, that would not have changed the nature in any way.
Thank you.
So Clark is found at tab 28, which starts at 560. And I outlined the facts this morning. I don't need to repeat those. The then maximum was £100,000. And the issue before the Court of Appeal was whether an ombudsman's decision was a judicial decision for the purpose of res judicata. And of course, the accepted decision, as was pointed out by the bench this morning, is something which is binding. And for the purpose of res judicata, one doesn't therefore need to consider whether or not a false complaint was itself a cause of action or a thing in action. That's what I meant, my lord, when I suggested, well, it may depend on if you're looking backwards. If you're looking backwards at a situation where, as here, the parties either were agreed or had not put in evidence to the contrary that there was a complete overlap with the cause of action, then in those circumstances, for the purposes of res judicata, that's going to be an end of it. But that doesn't ex post facto make the FOS claim incidental on any cause of action. So the assumption, which is key to the decision, I should show you that, that's page 572. And it's paragraph 53 on page 572. And that was in the context of whether there was an identity. I'm just trying to find where I pick up that word from. Yes, focus on the substance of what occurred before the Ombudsman, what's involved in the new proceedings. That's the top of the page. On this appeal, we have not heard argument on the extent to which that identity existed in the present case, since Judge Barrett QC concluded in summary terms that the issues the subject of the award of the Ombudsman were the same as those now raised in the action. Mr. Justice Cranston also took the view that there was a dispute at first instance, which this case was seeking to resolve. Judge Barrett was right to conclude that the adoption of merger applied. merger to some extent falls away. This decision was based on res judicata. There is no appeal to this court from these findings. That's the key thing. So the identity, the substance of the two being the same, wasn't an issue. It was in that context that the res judicata conclusion arose. There is one small quote, and I show it to you really because it assists, at least on the question of causes of action, if not on things in action. The judge in the present case looked at the legislation holistically. This is paragraph 46. First, he considered that the function of the Ombudsman was to deal with complaints and not causes of action. And he cited Lord Justice Ricks in Heather Moore and Edgecombe, where Lord Justice Ricks held that he, the Ombudsman, is after all dealing with complaints, not legal causes of action, within a particular regulatory setting. So the short point is, I show you that because of the quote from Lord Justice Ricks rather than anything else. And as I say, it's a distinction between complaints and causes of action. It doesn't go so far as to refer to things in action, but we respectfully say that the same could be made. The nature, once you've investigated the nature of the complaints, is such that the distinction is there. And I think that's as much as I wanted to show you in that decision. One point we particularly picked up in our skeleton and in our grounds, indeed, was the judge's remark about the repugnancy, as he put it, repugnant rather than repugnancy, but I turn this into general noun, of separating out the bringing of complaint from the right to receive redress. And our point here is that we respectfully suggest that the judge betrayed that his thinking may have been starting from a priori analytical framework rather than what we respectfully commend, which is the starting point must be the drafting choices made in DISP. And the question, therefore, isn't one that's to be addressed in the abstract. And so I'm sure the judge wouldn't have intended the label to be pejorative, but we respectfully say that the use of the word was to a degree a distraction, and that the focus must remain on the statutory construction exercise. Now, we in our skeleton have respectfully referred to two cases which we suggest help cast some light on whether the word repugnant was indeed correctly used. We don't suggest that these are exactly analogous situations, but we refer to them in response to the general proposition that rights, in inverted commas, and remedies can't be separated out. Our submission is that it all depends on context. So the first one was Auden Upton. That's at tab 15 of the authorities bundle at page 295. And just to outline the facts briefly, this was a decision of the Court of Appeal. The applicant had received treatment in 1991 for back pain, and he was subsequently judged bankrupt, and the respondent was appointed his trustee in bankruptcy with effect from October 1996. In February 1997, the applicant issued a writ against the doctor who treated him in 1991, claiming damages for negligence. And thereafter, some 6 months later, he was discharged from bankruptcy. The claim was for substantial damages, for loss of earnings in addition to general damages for pain and suffering. And the trustee in bankruptcy claimed entitlement to the damages for financial loss up to the date of discharge of the bankruptcy order. And there was then an application under section 303 for guidance. And then you'll see the holding at letter E. An action in negligence for personal injuries was a single cause of action. The action was a thing in action and therefore included in the bankrupt's property under section 436 of the Act of 1986. That the action was in part personal, insofar as it related to the body and mind of the applicant, but the claim for loss of earnings related to property which formed part of his estate as a bankrupt, and therefore constituted a hybrid claim, partly personal and partly relating to property. That an action was not within the exclusion from the definition of property unless it related only to a cause of action personal to the bankrupt. Pausing there is a common law exception, if I can call it that, to property in section 436 in respect of matters personal to the bankrupt. So it's not found on the face of that definition in 436. It's long established in case law. That a cause of action which included a property claim vested in the trustee, whether or not it included heads of damage which were personal to the applicant, that accordingly the cause of action vested in the trustee who held on a constructive trust for the applicant the right to recover damages for pain and suffering and other personal losses. So I'd ask you within the decision particularly to look at the judgment of Lord Justice Aldous, which is found at page 314. And paragraph starting just after letter B. The authorities are only consistent with the conclusion that the trustee is entitled to the damages for past and future loss of earnings and is not entitled to the damages for pain and suffering. As there is a single cause of action vested in the trustee, there is in my view nothing in the conclusion which imposes practical difficulties which the law cannot deal. The trustee as constructive trustee would have to account to the bankrupt for the property which he obtained inadvertently or by arrangement in an action which vested in him for the benefit of the creditors. The idea that the cause of action should vest in the bankrupt would not be acceptable, and compulsory joinder of both could lead to difficulties when the claim for loss of earnings was small compared with the potential costs of the litigation. In such a case, if the cause of action vested in him, the trustee would have to consider carefully his duty to the bankrupt and would probably, if requested, assign the cause of action to him. So, two things there. As with the legal problem was, a cause of action is a particular set of facts, as the court will know well. And the two types of loss came from that single set of facts. And so the law finds a pragmatic solution, an exception to the normal rule that says here, the trustee in bankruptcy becomes a constructive trustee of the part to which he's not entitled. So the right, the case is clear on this, the right is entirely the trustee in bankruptcy's. That's vested in him. But when it comes to dividing up the remedies, only the trustee can bring proceedings. The remedies can be divided in the way that was identified in the case. So it's not exactly our case, I don't suggest it is, but it's a sign of context being what matters. Separately, there is the Morgan and Gray case, which we say is of some importance. That's found in the authorities bundle at tab 6, starting at page 98. Now, headnotes were laconic in these days, and you'll see, very briefly put, the decision of Mr. Justice Dankworth's at the top of page 98. There is no enactment which provides that a shareholder of a company who is adjudicated bankrupt, whose name remains on the register, ceases to be a member and loses the right to vote or tender a proxy at meetings of the company, provided that the company is not in liquidation. The bankrupt can, accordingly, exercise such rights while his name remains on the register, unless there is some express provision to the contrary in the company's articles of association. Such vote must be exercised in accordance with the direction of the persons beneficially entitled. And the court would have seen there are parallels with our situation here. Because, as we've submitted, what DISP has created is a situation where the eligible complainant, in this case the bankrupt, we say does have the opportunity to continue to seek to vindicate his right directly, albeit a trustee is in position. But to the extent there's any award, in our case, then that has to go to the trustee, and that has a parallel here, that the exercise of the vote, which itself isn't a piece of property, but the exercise of the vote must be in accordance with the direction of the persons beneficially entitled. And within this decision, if I could ask you to turn to page 102 through to the top of 103, rather than I read that out, I simply ask the court to look through.
So you say all the individual bankrupts in the shop direct case could have lodged their own complaints?
Potentially, yes, though we would have strongly discouraged it. That's not the same as saying we'd be entitled to stop them. But thereafter, once complaints had been lodged, if they'd done so, I won't go into the mechanics of what happens, but certainly there are situations I know where the official receiver has, in addition, sought the use of the name of the underlying bankrupt as well, when referring matters. So that gets into matters of factual detail, which I'm sure don't happen universally, because sometimes the names of the bankrupts are known, but their addresses aren't known, their locations aren't. So one is obviously facing an unusual situation because of the bulk complaints. One's obviously looking at rules that look at individuals, but to adopt the label bulk complaint again for the moment, as the expiry of the 2019 deadline approached, there were substantial numbers of complaints lodged, not just by the OR, but by various others. So the numbers, therefore, did look very large. I can't give you an exact number for the complaints put in during the last year or so, but I suspect I could find something on that if that was of interest to the court.
Can I ask you about Morgan and Gray? There's no reference in Mr. Justice Danquet's judgment to the equivalent under the then Bankruptcy Acts, which I suspect was the Bankruptcy Act 1914, of a definition of property in Section 436 of the Insolvency Act. Under Section 436, property includes things in action, and certainly in some circumstances, a share is regarded as a thing in action. It's a bundle of rights, and it's not a thing in possession. And as you said earlier, there's some authority that all property is divisible into things in action and things in possession. Do we know what the form of the definition of property in the then Bankruptcy Acts was?
I have looked at it, but I haven't got it here. I suspect it was nearly the same, but expressed slightly differently. But I can look at that overnight for your lordship.
Thank you.
I've certainly got an old copy of Williams on my shelf in Chambers. Two things I'd perhaps say in relation to this. That is something which one can reasonably assume the court was aware of, not simply because of the identity of Mr. Justice Danquet himself, but also because counsel for the plaintiff was Mr. Harold Lightman,
Yes.
who was a well-known practitioner at the Chancery Bar, later a distinguished QC, so it would be a reasonable assumption that from both bench and bar there was a good knowledge. The other factor is, if one looks at page 100, there was a brief note of the arguments. And indeed, yes, Harold Christie, of course, I should have said, also, in constructed. So Harold Christie, I think, died in the late 1950s, was one of the leading lights of the Chancery Bar at the period, and died, I believe, while he was Treasurer of Lincoln's Inn in 1959 or thereabouts. So there's every reason to think they would have been fully apprised of the relevant legislation. But we'll double check as well. Then this was really by final specific points on the skeleton. You've got the point that it's sufficient, we say on our primary case, that a trustee in bankruptcy is authorised by law to bring complaints on behalf of a bankrupt. But once it's recognised that the trustee in bankruptcy is entitled to redress, I'm not going to repeat the submissions you've heard already, but we then went on at paragraphs 80.3 and 80.4 to drill deeper into insolvency law analysis to the extent it assisted by reference first to the power to get in property pursuant to section 305, and secondly by reference to case law, and that was the Singh case, which I'll show you. And the essence of that case was that it was concerning. I'll turn this up rather than start in the abstract. It's tab 21, page 376 forwards. And it was a slightly unusual case. It was a judicial review application. The case was about the standing of the bankrupt to bring judicial review proceedings. And the bankrupt was seeking to rely on the concept of equitable liability, which the court may have come across before, but it's a rather loosely structured fair dealing arrangement with the tax authorities. So if you come up with full disclosure, then at least this was no doubt how it was argued by him, then a solution to one's tax difficulties can be found. I'll try not to get too deep into that because it doesn't particularly have any bearing on the relevant passage. So what had happened was Mr. Singh was adjudicated bankrupt in 2006 based on unpaid pay-as-you-earn and national insurance. In 2007, the individual R was appointed as Mr. Singh's trustee in bankruptcy. Mr. Singh remained an undischarged bankrupt. He'd earlier lodged a judicial review application on the basis that HMRC had not applied the principle of equitable liability. Such application was settled by consent, and HMRC agreed to review Mr. Singh's tax liability applying the principles of equitable liability. Part of the noble practice required that the taxpayer had to bring his affairs up to date. So HMRC reviewed other years of assessment, and in broad terms, Mr. Singh was ultimately informed that his debt was £478,000 odd, which was notified in a letter. And Mr. Singh wished to bring judicial review proceedings, quashing the decision to submit a proof that was made by HMRC. And this is Mr. Justice Warren sitting as an upper tribunal tax and chancery chamber judge. So the position in relation to unassessed tax needs to be separately considered from cases where there had been a determination or assessment. But as with any contingent debt, HMRC was entitled to submit a proof in respect of the pre-bankruptcy period. It was not a requirement the trustee in bankruptcy had to insist on determination or assessment before accepting a proof. Still less was he required to appeal determination or assessment, even if one was made. The remedy of the bankrupt was to make an application in the bankruptcy court under section 303. And he said in 2, while the right to seek judicial review may not have vested in the trustee, as it was after acquired property, so this is a complication that perhaps doesn't trouble us too much, it didn't follow that Mr. Singh could himself bring judicial review proceedings. Now, it's in the context of that I wanted to turn to page 383. without, I hope, troubling you with the earlier authority which he was being addressed on, at 35, he'd expressed difficulty with an analysis, and one can see what his thinking is here. The reasoning in Heath and Tang is not that the right of appeal vests in the trustee, although it does where the assessment predates the bankruptcy. So in relation to a post-bankruptcy figure, rather the bankrupt has no standing to proceed with the appeal because he has no interest in the estate which is vested in the trustee and which comprises only the assets out of which the tax could be paid. The only assets, I apologise, out of which the tax could be paid. If the bankrupt has no standing, then the trustee must have standing, otherwise the unacceptable result would be reached under which no one had a right of appeal at all. So that was very much a fallback point, and I probably laboured it far more than it was worth. But our primary fallback is that if one has to go deeper into insolvency law, one finds in section 305, because the trustee in bankruptcy is tasked with getting in the insolvency estate, that's sufficient for this 2.7.2. But even if that weren't correct, the trustee in bankruptcy, we would say, would have the sort of rights identified by Mr. Justice Warren in a short passage on the assumption that he is entitled to the redress. If he alone is entitled to the redress and the bankrupt has no interest in that, we would say as that final fallback, that would be a position where what Mr. Justice Warren said would fall to be considered.
Would it follow, if that analysis was correct, that the bankrupt would not have the right to pursue a complaint in his own name?
Well, on that analysis, that would appear to be the prior conclusion that would have been reached, yes. So that only arises if the court was to conclude that, that the bankrupt doesn't have the rights, which I said he does, of course, my submission earlier.
Yes, but it does, for your purposes, draw a distinction between the vesting of the cause of action on the one hand and who has a locus standi to pursue it. I'll put it this way, it's about the vesting of the estate. That's the critical thing. That's the point Mr. Justice Warren says. It's not about the vesting of the appeal, right, because it relates to something which happened after the bankruptcy. What he's saying is all the assets in relation to which the appeal might have any relevance, out of which the debt could be paid, are already in the bankruptcy estate. So that's why there can't be any right, whatever the position might be. This is where scrolling through the earlier authorities might have given more context. But he's drawing the distinction specifically in relation to something that had happened post-bankruptcy. So that's why I've tried to deal with it with some caution, but perhaps not sufficient caution or not sufficient exposition. I think I understand. I still think that you can get some benefit from it. It's an illustration of a case where a right to bring a claim, in that case a claim for judicial review, was not vested of the trustee, but nevertheless...
Well, so I agree, my lord, yes. We would certainly say that is an identified feature. Yes.
That's certainly how I had read that.
Yes.
Right. Now, how are we doing in the overall roadmap?
You'll be pleased or otherwise to hear that I think I've referred to everything I wanted to address you on already by way of my opening submission.
That's very helpful.
Subject to any questions from the bench.
That's very helpful indeed. No check if my lady or my lord have any more questions. We do not. Thank you very much. Mr. Herberg, would it be convenient to pause there? And you'll start tomorrow?
Well, it might be. I mean, I'm happy to make some opening remarks, but I think it might be helpful.
It might be helpful
for me to take stock in the
yes, exactly.
information.
The only question I have for you both really is to make sure that we allow enough time tomorrow so that everyone can fairly put the submissions they need to put. And we bear in mind that you also have your respondent's notice. And so we have to build in sufficient time, not only for a reply, but also for any reply that may be needed on the respondent's notice points. Now, I have an outside commitment, a speaking commitment tomorrow after court, so it means that we can't sit later than 4:15. Now, against that background, if we start at 10:30 tomorrow, will that give us enough time?
Well, certainly on the respondent's notice point, it's important I take you to the first of those, which is the policy statement and the consultation papers, which are, we say, significant. The other two, the ultraviolet point, extremely short, and no doubt the court has it. There's not much I can add to that.
Yes.
And the last point is the alternative route, which again, which is the possibility of the OR itself being the eligible complainant. Now, again, that is a point which is effectively set out clearly in the skeleton. I hope I can do that pretty briefly. And my learned friend knows it because it has been ventilated before.
Yes.
So I don't think either of those will take a considerable amount of time, nor indeed I apprehend my learned friend reply to them. Before I get to that, of course, there is a lot to cover in the light of the interchanges today. There were points I need to pick up on.
Of course. But I'm sensing from you, but please correct me if I'm wrong, that you do think that it'll be fine if we begin at 10:30 tomorrow.
Well, I think so. I think so.
Very well.
The defendant has done a helpful lot of work in it, going through a lot of the material, which is common ground.
Yes, very well. We look forward to hearing from you at 10:30 tomorrow.